Hello, scholars. Today we're going to be discussing some of the other rights of the accused. Now, one of the main ones that most people talk about is the Fifth Amendment protection against self-incrimination. We'll discuss that. But there's also a number of other protections that are really important for us to understand. Some are actually built into the Constitution itself. Others are also buried in the Fifth Amendment, including the right to a grand jury and the double jeopardy protection. So those will be the things that we'll discuss today, and that'll wrap up our discussion of the protections of the rights of the accused. So let's pull up the PowerPoint, which is also on the Synergy page if you want to follow along, or you can just follow along as I do it. So again, the rights of the accused, we should understand that the founders and the framers were sensitive to the idea that those accused of crime are often persecuted. And certainly if you look at the founders during the revolution, Britain would use criminal statutes as basically a way of attempting to intimidate or silence political dissidents. Something that we've seen done in lots of other countries, including this one. So that's why. So there's a reason we have the rights of the accused. Is that it has been criminal statutes have been used to silence political opponents and to target minorities, and so this is one of the reasons why we have these protections to protect these groups. Now, one of the first important protections is the right of habeas corpus. Now, habeas corpus goes way, way, way back, right? The idea that the government, habeas corpus, the rough Latin translation, is to produce the body, and it requires the government to prove why it's thrown someone in jail. So it's a court order, it's a writ, and if a writ of habeas corpus is issued, the government has to justify why someone is being held. Congress does have the ability to suspend the writ of habeas corpus, but only in cases of rebellion or invasion. The president may not do it unilaterally, but during the early days of the Civil War, Lincoln did use it to arrest people in the border states who were advocating for those border states to join the Confederacy. So in times of crisis, we've seen habeas corpus, the protection against habeas corpus violated, but generally this is a fundamental value in our system, that the government cannot just arrest you and throw you in jail and forget about you. The government has got to be able to justify your incarceration. So this is an important right, and it's in the body of the Constitution. Two other rights, the Bill of Attainder and the prohibition against ex post facto. A Bill of Attainder, back in ye olde England days, sometimes the Bill of Attainder would be used to punish political dissidents. If somebody had made Parliament mad, they would make it a law that it would be illegal for you to be that person. So literally the legislature would make it a law that you were now illegal. Now, obviously, that is deeply problematic, and it allowed for the targeting of political dissidents and political minorities. And so the Congress cannot pass bills of attainder. In addition, there is a prohibition in the Constitution against what we call ex post facto prosecutions. So if someone committed a crime, someone did something that was legal when they did it, they cannot be prosecuted for it later. So let's say, tomorrow it becomes illegal to lecture online wearing a red shirt. I still could not be punished because it was legal when I did it today. So again, ex post facto, the prohibition of ex post facto, the prohibition of bills of attainder, we take them for granted. And if we didn't have them, we'd really wish we'd had them. But because we have them, we take them for granted. So the protection of habeas corpus, prohibition of bills of attainder, prohibition of ex post facto rules. All of these are things that are very important to us, very important to our protection of our civil liberties, and we should be very happy we have them, though often we take them for granted. Now, so let's move on now to the Fifth Amendment. We already talked about the Fourth Amendment previously, the search and seizure protections. Now let's talk about the Fifth Amendment, what actually has a number of important protections. One of them is the grand jury. No person shall be held to answer for a capital or other infamous crime. No, and by that we mean really a felony, unless on a presentment or indictment of a grand jury. Okay, so we have the grand jury protection. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb. Now we call this the double jeopardy protection. And lastly, nor shall be compelled in any criminal case to be a witness against himself. And this is the self-incrimination, the prohibition against self-incrimination. So these are the three legal protections that we find in the Fifth Amendment. So let's look at the first one, grand jury. Now, actually, this number, apparently in Clackamas County, the grand juries are actually smaller than this number. But again, a grand jury is a jury that only hears from the prosecution. Right. Only the prosecution presents its case. The defense doesn't present its case, but the grand jury does get to ask questions of the prosecution, and so that's sort of interesting. The burden, of course, is probable cause, so it's not beyond a reasonable doubt like what we call a petite jury. That's the jury that actually convicts you or acquits you. A grand jury is what we do, but to accuse you. You don't need a unanimous grand jury. It needs to be some sort of a majority. And again, how big that majority is depends on what municipality or jurisdiction you're in. And what the grand jury will do is they will either issue an indictment, which is a formal accusation that someone has committed a specific criminal offense, or they will issue what's called no true bill, where they'll basically not indict you. Now, that doesn't mean you can't be indicted later. Maybe the prosecution can try again, but the idea is the grand jury needs to agree that there is probable cause. Now, why do we do this for felonies? We don't do it for misdemeanors. We don't do it for violations. Remember, a felony is any crime punishable by more than a year in jail. The reason we do this is that there was an understanding, even back to the framers, that if we accuse someone of a really horrible crime, that is going to harm their reputation in their community. And so before we formally accuse someone of a horrible crime, we really want to make sure that the government has at least some good evidence that the person actually committed that crime. So the government has got to at least show probable cause before there's a formal accusation against the person. And so that's called, again, an indictment. So if a grand jury indicts you, means you've now been formally accused of the crime. And now we're going to go through the process of, again, pre-trial hearings and trial and all that good stuff. But first there has to be the indictment. Now, again, we don't require this for misdemeanors. We don't require this for like traffic violations. We don't require it for civil litigation, but we do require it for felony prosecution. So that's the grand jury protection. There is a joke in law school that grand juries will indict a ham sandwich. Like most law school jokes, it's not actually funny, but it does sort of have an element of truth to it, which is because the grand jury only gets the evidence from the prosecution and not the defense, they are generally seen as likely to indict. But there have been some very notable examples where the grand jury has refused to indict someone. Much to the frustration of the government. The next prohibition or protection that we saw in the Fifth Amendment is double jeopardy. Now, the reason we have this is because, again, we don't want the government to try you again and again and again until it finally gets the conviction it always wanted. So once you've been tried and acquitted, so you have to be found not guilty, you cannot be tried on the same charges for the same crime. Now, you could be charged with different, maybe instead of being charged with a felony for, I don't know, robbery, maybe they'll charge you for shoplifting, which is a misdemeanor. There might be civil litigation involved where maybe the shop owner would sue you for the value of the candy bar. Who knows? But the idea is if you've been tried and acquitted, you cannot be tried again. Now, hung juries don't count, mistrials don't count. So if the jury ends in a mistrial, the government can try you again. But if there's an acquittal, you can't be tried on those charges again. Now, if you violated a law where there's both state and federal charges, and let's say you're acquitted on state charges, you could theoretically be charged under federal law if there is some sort of equivalent federal law that you could be charged on. That doesn't happen that often. There's only so many times where a criminal act violates both state and federal law. It also doesn't apply to civil litigation. So you can be acquitted in a criminal case, but still be found responsible in a civil case. So probably one of the best known examples of that is the O.J. Simpson case. O.J. Simpson was acquitted of murdering his ex-wife and her friend in the criminal system, but then the survivors, the relatives of his two victims, then sued in civil court, and he was found responsible for those deaths. Now, it may sound sort of, nonsensical. How can you be found not guilty in one court but found responsible in another? It sort of makes sense, though, because in the criminal's case, the burden is beyond a reasonable doubt. That's a much higher burden. Whereas in a civil case, of course, the burden is preponderance of evidence, which is a much lower burden. So that's the reason why O.J. Simpson was found not guilty of the murder. Part of the reason, anyway, that O.J. Simpson was found not responsible, or was acquitted for murdering two people, but then found civilly responsible for basically murdering two people. So that's the double jeopardy protection. It's an interesting protection, and it does exist for a reason. Now, probably though, the Fifth Amendment right that generates sort of the greatest discussion is the self-incrimination. Nor shall be compelled in any criminal case to be a witness against themselves. Now, this is a response to the British practice of basically torturing confessions, or asking someone, did you do it? And if you say, no, I didn't do it, and then they can prove that you did, then they additionally prosecute you for lying. Or if you admit to it, well, then they prosecute you for doing so, for doing the crime. So in the British practice of sort of compelling you to testify, it created all sorts of binds for those accused of crimes. So it only applies to oral statements. You cannot be forced to basically testify against yourself, but you can be required to give voice samples, fingerprints, do lineups, or even present identification if asked by the police if they have reasonable suspicion. So the self-incrimination protection is really about coerced confessions, making you admit to a crime that you did or didn't do. So this is why this protection exists. And over time, it's really evolved, right? Earlier, in our country's history, we understood it to mostly mean the police can't torture you. Now it means more than that. It means that there are protections during police interrogations. And what's happened is the police have gotten, again, in the olden days, sometimes the police would get confessions through torture. Now the police don't do that, but they still they can be very, very sophisticated in their interrogations, so sophisticated and so skilled in their interrogations that people will actually admit to crimes they didn't commit. And so the court is now in a slightly complicated situation where how do you still allow the police to, get confessions, but not coerce false confessions? Now, in terms of identification, this one comes up often. If the police ask you for ID, do you need to present ID? There is Supreme Court cases on this, and the general rule is if the police ask for it, you do need to present identification, or you do need to identify yourself. It's not considered self-incrimination, but the police do need reasonable suspicion that you're up to no good. Now, remember, reasonable suspicion is a low burden. And again, let's remember my disclaimer with the Fourth Amendment. I am not an attorney. If you ever get yourself involved in a criminal investigation, you are advised to speak to your own attorney to answer any specific questions about any specific legal matter that you happen to find yourself in. I can only talk about general constitutional principles. I am not an attorney, and I have not passed the bar. So that's the general rule for self-incrimination. Now, again, one of the emerging problems is the police interrogations are getting awfully good. And as the police get more sophisticated, they often can interestingly enough get people to admit to crimes they didn't actually commit. So how do you do that? Well, the solution for the courts has been basically to extend a right to remain silent. Um, that if you remain silent, if you say I'm not going to talk to you, I'm going to take the fifth, I want to wait to talk to my lawyer, sort of any iteration on that, um, that ends the interrogation, right? So you have a right to remain silent. You don't have to answer questions if you don't want to. Um, and furthermore, remaining silent cannot generate probable cause. For arrest, for a search, it can't even be brought up during your trial. Um, so that's sort of the court's solution to the problem is if the police are asking you questions that you don't want to answer, you do not need to answer them. And your refusal to answer them does not create a justification then for arrest, for search. It can't even come up in trial. So again, I want to kind of reiterate that. Now, one of the things the court has said is you need to explicitly cite the right. So if you're chatting and chatting and chatting, and the police then say, "Hey, did you go to the party yesterday?" and you say nothing, you don't explicitly cite the right, and then they say, "Hey, what's your dog's name?" and you say, "Oh, my dog's name is Mr. Fluffkins," and then you talk about Mr. Fluffkins. The police can then mention in trial, you were chatting and chatting until we talked about the party, then they said nothing. So the idea is once you cite, once you claim a right to remain silent, you're not supposed to talk anymore, right? You're not allowed to selectively say one thing and say the other. Well, you can, but that'll be brought up in trial and can be used against you. So that's sort of one of the wrinkles about the right to remain silent. That if you use it, you're supposed to then use it and not sort of keep chatting. Because if you keep chatting, then that what you're saying can then be used. Now there are two cases that are especially important um, uh, about the self-incrimination right: Miranda v. Arizona and Escobedo versus Illinois. In Miranda, this guy was a really horrible person. And Ernesto Miranda was arrested for kidnapping and sexual assault. But he was interrogated, and he ended up making a bunch of statements that were deeply um, deeply suspicious. Basically, brought a lot of attention to himself. But Ernesto Miranda was not particularly well educated, and he was not aware of his rights. And so the court ruled that one of the ways we can protect the Fifth Amendment right is that the police have to tell you what your rights are, right? That way, if someone is unaware, and of course, today, because we all watch cop shows, we got a general idea of the Miranda warning. You have the right to remain silent. Anything you say can and will be used in a court, and blah, 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 blah. So everyone's familiar with the Miranda warnings, but the police are still required to say them. They are only required to say them, though, if you are in custody. Okay. If you are arrested, then they have to Mirandize you. If you can leave, if you can walk away, they don't need to Mirandize you. If it's a Terry stop where they're only holding you for 20 minutes, they don't need to Mirandize you. And if it's a traffic stop, because that's also of a limited duration, you also they also don't need to Mirandize you. So they don't need to Mirandize you in any circumstance. They really only need to Mirandize you if you're in custody, or the average person would think they're in custody. Traffic stops, Terry stops, situations where you can just walk away, no Miranda is required. Okay, there are some exceptions. Emergency public safety. If the police think you planted in a bomb, let's say, for instance, in the Boston bombing, one of the suspects, they did not Mirandize him before they interrogated him because they thought he might have planted a bomb somewhere. So they interrogated him before they Mirandized him. So in the event that there is an emergency, Sometimes there's something called excited utterance, where if the police approach someone and the person blurts out, I shot him and I'm glad I did it, ha 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 ha, something like that. Well, that'd be an excited utterance, and because the police didn't even have a chance to Mirandize, that evidence would still be allowed. Routine booking questions. So if you're arrested and the police sit you down and they're going to say, do you have any prior felonies, or are you carrying weapons, or I have no idea what the routine booking questions are, but I imagine there are things like, do you have any priors? Are you carrying any weapons? Do you have a history of mental illness? Those questions, those routine booking questions, are allowed to be asked. And lastly, the use of jailhouse informants. If you're put in a cell and your cellmate sort of asks, "Hey, what are you in for?" and you decide to, tell about the crime you committed, that jailhouse informant then can go to the police and say what you told them, and for that reason. And so that doesn't count as the informant is not required to Mirandize you. This, by the way, is one of the reasons that defense attorneys will usually say, if you're in jail or if you're in, a holding cell or something like that, don't chat with your fellow prisoners, because they may have been either put there by the police as informants, or they may later just kind of, talk to the police about what you said as a way of sort of lessening their own criminal prosecution. So these are all exceptions to the Miranda warning. But the idea of the Miranda warning is that some people don't know what their rights are, and so this is one of the ways to protect against that. Now, the other protection is this right to an attorney during interrogation. Again, one of the protections, one of the concerns we have, rather, about interrogations is that you're going to confess to a crime you didn't commit. And so one of the protections for that is if you have your attorney with you, your attorney's not going to let you do that, right? Your attorney is basically not going to let you confess to something you didn't do. So under Escobedo versus Illinois, you have a right to an attorney not only during your trial, which is established in Gideon versus Wainwright, but you also have a right to an attorney during your interrogation. Now, once you ask for an attorney, basically the interrogation has to terminate until your attorney is present. Okay. Once you ask for an attorney, bang, the interrogation has to be over. Now, if you ask for an attorney and then you decide to then just keep chatting away, and there's two cases that are really sort of interesting / disturbing, called Brewer versus Williams and Rhode Island versus Ennis, that sort of get into this question. But the idea is, if you continue to talk to the police, even after you've asked for an attorney, then that evidence can still be used. Um, if you don't have money for an attorney, you will be eventually given an attorney. The night of your arrest, you won't be. So, in other words, if you're arrested, and you say, "I want an attorney," and you don't have your own personal attorney on retainer or something like that, what will occur at that point then is usually the police will hand you a phone, which is some public defender, and the public defender will basically say something to the extent of, "Don't talk to anybody, don't say anything. Somebody will talk to you in the morning." So you do have a right to an attorney during interrogation. Once you say you want an attorney, the interrogation is supposed to stop until your attorney is present. And again, if you can't afford an attorney, one will be provided for you. Now, as a juvenile, you usually do have a right to have your parents present during an interrogation. So that's sort of a variation of that, though sometimes parents aren't as useful in protecting the rights of juvenile defendants as we'd like. So that is our discussion of the Fifth Amendment and some of the criminal protection rights in the Constitution itself. I hope you've enjoyed today's discussion. We will have yeah, so I will talk to you guys soon. Be sure to keep checking the Synergy page. Have a good day.